and in national papers, raising awareness of the need for cohabitation reform. So in this session, Graeme is going to talk about resolution, a view from the coalface. So over to you.
Right, well, good afternoon, everybody in the room and online. I believe there are lots of people online from what I can see. I'm going to talk this afternoon, really giving a view from the coalface. I'm a practitioner as well as a campaigner, and I'm very proud to be chair of Resolution's Cohabitation Committee. And the title of this talk today is Recap, Responsibility and Reset, because I think we need to look back at where we are, look at our responsibilities now, and look at how we reset the campaign going forward. Oh, just think that doesn't seem to work. So no. Okay, I think it's just on here.
What about now?
Yeah, okay, well, I'll use that. Okay, so really in terms of setting out an agenda for my talk today, where are we today? Why is the law not fit for purpose? What are our proposals for reform? And I'm referring here to the resolution campaign. And also, what is our responsibility going forward? So what is it that we need from resolution, which is made up of 6,500 family justice professionals and family lawyers generally, to reset the campaign for cohabitation law reform? So in order to look at this, we need to start by looking at where it stands. And the picture you've got on the screen is Parliament, because it's Parliament that we're going to have to look for change in this area. And really, just to recap on the UK government's current position, we know that in last November, the government rejected the main findings of an inquiry by the Select Committee recommending better legal protection for individuals cohabiting in England and Wales. Now, the good news about that was that Parliament basically took up pretty much the whole of resolution's evidence. I'm very proud to say both the oral and written evidence, as well as the evidence of many other legal professional organisations. And there was very good reasons why, but I'm afraid the government rejected that, and that reflected flawed logic and kicking the situation into the long grass. That's not my quotes on it, that's Caroline Noakes, who headed up the Select Committee. And we know the reasons for this. The ministers said that they needed to complete existing forms around marriage. We've heard about that this afternoon, and we've heard Professor Probert talk about the need for cohabitation reform in line with weddings reform, and also the need to review the law on financial provision around divorce. Now, my point about that is, yes, there are things that could be better about financial remedies law, but we actually have quite good law and it operates, and most of the time we do actually settle cases. So there is a discretion, there is law that exists. But they said that needed to happen before new legal changes for cohabitants. But we still believe that reform is needed urgently, because we know many couples are unaware that they do not have the same legal protections as married couples. And what I'm talking about here is our experience from who comes in our doors, in addition to the research that Anne has obtained. And we say that more of the same is no longer good enough. Resolution and family lawyers, we need to take the action to reset this campaign for legal reform and cohabitation law. So next question is, why is the law unfit for purpose? Well, I think we have to go back 40 years ago. Now, you'll see on the slides, at the bottom of the slides, it says 40 years, because we are celebrating this year the 40th anniversary of Resolution as an organisation, which is great. But what is not great is that it's also the 40th anniversary of a case called Burns and Burns. Although it's a 1984 citation, it was decided in 1983. And you may ask, why are we still talking about 1983? Well, why? Because the law is still actually the same. Because Mrs. Burns, who had lived together with Mr. Burns, had taken Mr. Burns' name, everything but the marriage certificate, after a very lengthy cohabitation, having brought up Mr. Burns's children, was left with no rights in that case. And this is the Court of Appeal talking about the situation in 1983, commenting on Mrs. Burns's lack of right. The unfairness of this is not a matter for the courts, it's a matter for Parliament. That's Lord Justice Fox and Lord Justice May looking at a comparison of the rights to if she had been married. I think she can justifiably say that fate has not been kind to her. This is pre-White and White. This is pre-Miller and Macfarlane. The law in those days was very different. I know, I came into practice in 1996. So that's what the Court of Appeal were saying then. They haven't really had an opportunity to say it again, because if you're on Mrs. Burns' position, you can't even bring the case. And I just wonder how many Mrs. Burns there have been since 1983, and how many Mrs. Burns there will continue to be until the law is reformed. So what's changed since then? Well, I think it was very eloquently described by Anne, so I won't go into it in too much depth, but we know that many live together now. They have children outside of marriage. The statistics are pretty full about that. That people are living longer, and there's a variety of living arrangements. There are lots of choices. And some people who actually want to marry can't get married, so they live together. And we do see those cases. But what we do know, and what's undeniable, it's the fastest growing type of family in the UK. There's over 3.6 million people living in this country, and that's a statistic from the House of Commons briefing library. There is no evidence that this trend is going to reduce. And as practitioners, we have to deal with the cases that come into our offices, not what people would like the situation to be. So in terms of an organisation, we've conducted various surveys in recent years. And as you can see, we've got considerable experience of about cohabitants and their lack of awareness. And the fact is, in 2017, to coincide with our first awareness week, nearly 100% of respondents we found were unable to help due to the lack of legal protection. And 2 years later, it was the same results. I can also reveal there's been a survey that's about to be released showing that the position is still widespread. It's very high up there in terms of resolution members' priority for reform. So there's an old adage that hard cases make bad law. I know that because I see hard cases in my office. I know that property law remedies are inappropriate for unmarried families. They don't work. When we go to council, and there's some very good counsel here today, they advise on the remedies. Often I'm not expecting the result. Nobody seems to like the answers. It's complicated, it's uncertain, and it's very case specific. It's also extremely expensive. It can cost between £50,000 and £100,000 between the couple to take the case to trial, and it might, even at the end of that, result in an unfair outcome. So what can we do about it? Well, we can use out of court dispute resolution processes. Our organisation champions those processes, and they can facilitate fairer outcomes, but it takes two to engage in that, and they both have to understand the concept of fairness, which is actually different to the concept of fairness under the law. And the problem is we don't have safety net legislation. So doing the best we can, we do the best we can, but I believe that many people out there are heavily disadvantaged. So we say the law is not fit for purpose. Why? Because we have come across many people in this Burns scenario, because we feel that under the current law, the party that's economically stronger doesn't take responsibility, is not forced to take responsibility for a former partner when a relationship breaks down. I've seen evidence of that. I've seen reported cases in the Central London County Court. I've seen it reported in the Standard and the Mail. We know it happens. Also, the problems that occur when you trust in common law rights and protections, that's been described by Anne earlier along. The problem really is that people don't know their rights until they come to see the lawyer, and by that time it's too late. And it doesn't matter what you do about it, you cannot repair the situation, because what they should have done is been very clear in their intentions at the time of the transaction or the purchase, but it's far too late. In some cases, it's 20 years later. And we know also from earlier talks today that there are problems when religious marriage is consciously chosen as trial marriage. And additionally, we can see that there's uncertainty, unfairness and hardship where the couple have only had a non-qualifying wedding ceremony. So those are some of the problems. Now, some people say, well, with cohabitation, are you trying to equate that with marriage? To be very clear, that's never been Resolution's position, and it won't be going forward. We know that cohabitants have not made the public commitment of marriage. But what we also know is that by improving these remedies, we will resolve the mischief of those who deliberately avoid these responsibilities of marriage or civil partnership to avoid financial responsibility. And we say that's wrong. It's also possible under proposed reforms to be very clear that there would be a presumption that each cohabitant on separation would, as far as possible, be self-supporting. So there are models to show the distinctions. So what can we learn from abroad? I can't possibly compete with the talks we've had this morning. I'm not going to try to, but a few things I've learned by watching the excellent webinars put on last year was that we do know the law's got to be clear, it's got to be fit for purpose, and it's got to be useful. I've heard also today from Ireland, the situation there, and from Scotland. But also we've got to be very careful. We've got to look at how people live together in this country, look at the diversity of our population and see what the appropriate laws are going to be. We feel that rights should be automatic, but subject to an opt-out scheme. And we know that these opt-out schemes are working quite well in Australia. We also know that one of the big fears of government introducing new legislation does not have to cause controversy. It didn't cause controversy in Australia and Canada, for example, and we've spoken to practitioners who have actually come on webinars to demonstrate that in the last couple of years. So is it an equalities issue? Well, we had a select committee about it, and I feel that the more that time goes on and the more numbers of people cohabiting, the more it does become an equalities issue and the more that we understand about the problems that arise. So when it comes to making decisions, we know they're unconscious decisions about who's looking after the children, who's looking after elderly relatives. It does mean that it compromises the person who's got less money because they cannot work and they therefore cannot make the financial contributions required under trust law. They don't have the same ability to claim a share of assets, and then you have to rely on complex trust issues, which, you believe me, in practice are difficult to work out. And I sometimes go to conferences lasting 2 hours looking through 400 pages of papers to work out what people meant. So where's the restriction? You can't make any claims about pensions. Pension sharing legislation has been in for years, very helpful on divorce, and you can't claim maintenance for them for yourself. That's a very useful, flexible tool in other countries. So as Anne said, it's women who tend to be disproportionately affected. And we say that the current law is arguably discriminatory. In my caseload and caseload of many other people I know, it's often the women who are the ones who are most disadvantaged. And that's been confirmed also generally within the membership of Resolution in a survey in 2017 and 2019. And we also doubt, I know that Professor Probert took a sort of small sample, but we believe that there's unlikely to be high public awareness amongst those in Islamic marriage about the difficulties they will find themselves economically if they don't have a recognised marriage. So this, I think, is the thing I feel most strongly about, which is the children of cohabiting partners. And if you look at the first part of my slide, what the Law Commissioner has been recommending since 1982, I'm happy to go on record that I think it's an absolute disgrace that the children of unmarried parents have any less rights than the children of married parents. They didn't put themselves in that position. Why, as a civilized society in the 21st century, is this happening? I have no idea. What I do know is that Schedule 1 is very old, it doesn't work very well, and you can't use it very much. I don't know many lawyers who do use it very much. That's the truth of it. I get some of the cases because I'm known for this type of work, but people don't use it very often. It's often a situation where the stronger party has an income of over £156,000 gross per annum. I don't know what the national average income is, but it's considerably less. You're looking at a situation where you're outside the jurisdiction of the CMS, possibly a situation where a child is being educated, or there are very substantial assets involved. But even in those cases, we know outright transfers of property are rare. So you're working with your hands tied behind your back. And when it comes to future needs beyond childhood or education, which means a lot to parents and a lot to the family, it's not even a consideration. So let's look at reform and what can be done about this. Well, we say there should be a legal definition of cohabitation to distinguish between cohabitation and marriage and civil partnership. We also say there should be eligibility, so a minimum period of living together and demonstrating a committed relationship. We've identified relevant factors for living together. I said in my evidence, and I'm happy to abide by that, that when we see somebody in practice cohabiting, you know it when you see it, so I don't think it's difficult to identify. But I do believe that cohabitation should be defined by reference to commitment and interdependency. There's always been some debate about the period of living together, but we believe it's 2 years. And cohabitants with children, we say there should be no minimum cohabitation period. Right, I think I haven't got a lot of time left, so I'm going to dart through. Oh, I think I've lost it now. Sorry. Let's go. Right, we are asking for rights and responsibilities. We say that it should be opt-out. We say there should be flexibility, and that flexibility would help in terms of property rights, allowing for childcare payments, and also applying for maintenance. But it has to be for that limited period to allow to adjust to become self-supporting. We're in favour of that. We basically accept the Law Commission's 2011 recommendations to improve rights on death, which would mean bringing into legislation a draft bill that already exists. That's our position on that. And we do believe that cohabitants should be treated the same as married couples and civil partners for tax purposes on death. We do believe that Schedule 1 has been is ripe for reform, and that means extending the length and the range of orders and criteria to be considered, and we believe that would be relatively straightforward to do. I suppose fundamentally what we're looking here is in terms of a discretion to compensate. And we think that in England and Wales, discretionary processes work well. We've had the Matrimonial Causes Act for many years. As a practitioner, I've used it all my life. We have guidance from time to time. Our law is flexible, generally works well. We know the parameters when we see them. But allowing us to have a wider menu of options in terms of the financial remedies available is very helpful in divorce cases, and would also be helpful for cohabitation cases and would make a huge amount of difference. But we do distinguish this by saying it should be a remedy of compensation rather than needs or sharing. Now, I've got very little time for the action plan, but I am going to speak a bit later on. I just want to say what we've got to be clear about is that doing what we've done for the last 40 years is no longer enough. We're going to have to reset this campaign. That means taking the responsibility as family lawyers to do the right thing. We know that the situation is unfair and wrong. We need to raise public awareness, and we are doing our best to do that. Resolution does that. We've run campaigns. We've worked with the University of Exeter to improve education in the classrooms. We will do all of that. But we do need to educate and inform the general public, particularly those who are marginalised and vulnerable groups. That was something that came out of the Select Committee work. We need to dispel myths and correct misinformation. But most importantly, we ourselves need to have a reboot. We need to re-energise and re-engage the people who are going to help us to get this over the line. And that means MPs, the media and lawyers. And I fully believe that's achievable. Thank you very much.
Thank you. So it's my pleasure now to introduce as our second speaker, Joshua Viney, who is a barrister at Hare Court, and he's also a leading financial remedies lawyer and is author of several practitioner texts on the subject. So Joshua's talk, as you'll see in a second, is called Schedule 1, Fit for Modern Society.
Yeah. I have no idea who it is.
It's linked to this kind of thing that you can put it on there. Okay.
I just click that again. Good afternoon. I'm going to be speaking to you about Schedule 1 and whether it's time that some of the basic aspects of the statute and the schedule are reconsidered to fit in with modern life and values. Certainly because I consider, when looking at cohabitants, they can be, to certain cohabitants, discriminatory. I've done a lengthy PowerPoint with, at best, mediocre graphics. So hopefully that's going to get me through the next 20 minutes. But after the PowerPoint, if anyone has any questions, I'm more than happy to take them. This really comes out of the case of Siddiqui, which is a case I did with Justin Warshaw, KC, in the Court of Appeal, where a middle-aged solicitor sought child maintenance from his parents, who were our clients. Before anyone gets any ideas, he lost. It was quite an interesting case for me because I think, as Graeme says, actually you don't come across Schedule 1 very much, and I really had to get my arms very deep into the mechanics of the Act and how it works. The background of the Act, you know, we were looking at kind of 200 years of history of child maintenance, and also the Human Rights Act. And the history of Schedule 1 is, I think, probably pretty noble. It was trying to eradicate the difference between the treatment of children born to married parents and unmarried parents, which was part of a wider move to get rid of discrimination based on birth status. So it's difficult to see it as anything other than progressive for its time, although, as Graeme notes, query how successful it's been in the long run. I reckon that most practitioners, myself included, have probably fallen into the easy trap of viewing Schedule 1 as perhaps a more modern statute than, for example, the Matrimonial Causes Act. Probably because, for me, Schedule 1 and I are the same age. But I suspect it's often because the Matrimonial Causes Act is now in its 6th decade. But what we do have to remember is that Schedule 1 is a statute of its time. It was drafted long before same-sex couples could adopt, before the child maintenance service even existed, and before the present surrogacy legislation existed. And the society we live in now is so starkly different from the 80s. And as Graeme was identifying just now, 30 years on, and we all know there are a lot of problems with it. From a macro perspective, we all know it's mainly used by the very wealthy. In my practice, it's footballers you're going to come across most commonly, to the exclusion of most cohabitants. I reckon it's probably 99% of people aren't going to get above the threshold. So you're not going to have anything to do with Schedule 1 there. You're going to be looking at the child maintenance service. And finding case law for mid to low level cases in Schedule 1, it would be quite a good PhD, I reckon, although a short one. There's not much there. And the guiding authorities continue to be cases like Re-P. And I was tickled this morning when I was looking at what the assets were in Re-P, and actually you don't know, because the father was so wealthy. He says, without financial embarrassment, inverted commas, he could raise and pay any sum of money that the court was going to order. And his house alone cost more than half of the value of the Millers, if we do a comparative case to the Matrimonial Causes Act, entire asset base. So completely different scales here. And of course, I would be remiss if I didn't identify as a major problem the interplay with the Child Support Act. On a micro level, costs rules are extremely prohibitive. It allows rich parents, often fathers, to bully and outspend the poorer parent, often mothers. And then, of course, other more micro issues. There's limited provision for adult children, which I think, again, Graeme was referencing. So lots of problems, but I am not going to talk about those today. That's for another occasion. I'm going to look at something more specific and ask whether Schedule 1 is discriminatory towards certain cohabitants, prioritizing, perversely, given its history and its goal, marital status. I'm going to start very simply and look at who can make a claim. So forgive me for teaching a grandmother to suck eggs. The applicant in Schedule 1 is drafted incredibly widely. By virtue of the statute and the rules, effectively anyone can apply who has a lives with order for a child, even a local authority. Where things become a little bit more complicated is who can be the respondent, because under paragraph 1, subparagraph 2, the respondent can only be a parent. There's no statutory definition of a parent, although paragraph 16 does define what a parent includes, and that is any party to a marriage, whether or not subsisting, in relation to whom the child concerned is a child of the family. The language is repeated for those in civil partnerships. Whilst there's no statutory definition of a parent, in the case of T and B, back in 2010, Mr. Justice Moylan, as he then was, sought to clarify what a parent included, and he identified three things. First, a biological parent. Second, parents who've become a parent by operation of the law, such as by adoption or under surrogacy legislation. And third, parents as identified in paragraph 16, which is what we've just been looking at, namely parties to a marriage or civil partnership. The judge was very clear, having parental responsibility in the context of Schedule 1 did not make a party a parent. For completeness, a child of the family is defined by section 105 of the Children Act as a child of both of them or any other child other than a child placed in as a foster parent who is treated by both of them as a child of the family. Which is a nice bit of circular drafting. What I'm going to do now is walk you through several different scenarios. A lot of films over the last year have focused on the idea of a multiverse, which is the theory that there are an infinite number of universes where you're dealing with infinity. Possibilities are endless. So you could have another universe with a minor change. I could have brown hair, if only. And you could have another universe with vastly different changes. And so to expose how weird Schedule 1 is, I'm going to introduce you to Prince Harry and the Multiverse of Madness. I promised you mediocre graphics, and I really was not being humble when I said that. And together with Prince Harry, we're going to explore family law, where we look at these other universes and how members of the royal family are in relationships with each other, and in the process displaying to you how bizarre Schedule 1 can be. So our first multiverse is going to be the Prince and Princess of Wales. And in another universe, like much of the population, they decide to cohabit rather than marry. And they have a child, meet baby Louis. I resisted the urge to use Prince George and a Gary Janetti meme here. Anyway, Kate, William, Prince Louis, happily together, cohabiting relationship between the parents until their relationship breaks down. Why is it broken down? George Clooney. Definitely an upgrade. And they decide to get married. Another graphical triumph here. So poor William is heartbroken, but everyone soldiers on. And there's a joint lives with order. William takes on the role of primary carer for Prince Louis, but in this universe, he's not got the royal estate or public purse to fall back on. And Kate and George Clooney live happily together as a married couple and treat Prince Louis as a child of the family. So what are William's options? Well, he could pursue Kate. In a normal way, it's probably the most obvious answer. But remember paragraph 16, you could also pursue George Clooney because George Clooney is in a marriage and Prince Louis is treated as a child of the family. And if you were to pursue George Clooney, the court has a discretion under paragraph 4.2 of Schedule 1, where whether a person who's not the mother or father has assumed responsibility for the maintenance of the child and to the extent which they've done so and for how long. These are the things that the court's going to have to consider. And it'll also consider whether they've done so knowing that the child is not theirs and the liability of the other person to maintain the child, in that case, William. So let's assume William has never met George Clooney. Let's assume that George Clooney has been the sole financial support for Prince Louis for a couple of years while Prince Louis has been living with him and Kate. And that could put him squarely in the court's eye line. Let's make George Clooney's connection even more remote, because remember, the marriage does not have to be subsisting. So technically, again, heartbreak, they break up. And Prince Louis now living between these two. Technically, William could still make a claim against George Clooney. I think it'd be a very difficult case. I'm going to stick with Prince William because I like to use him as what I like to call an analogy. In this universe, he's in a relationship with Mike Tyndall. And they live together for 5 years and they decide they want to have a baby. Who steps up? It's Meghan Markle. And soon their newborn baby arrives. Baby Timothy, I'm going to call him. And here's the happy couple with baby Timothy. So Prince William is the biological father. Mike Tyndall is not, and he doesn't take any step to become baby Timothy's legal father, as neither Mike or William think it's necessary, as they both see and view each other as fathers. In fact, it isn't even legally possible for Mike Tyndall to be registered when going through the surrogacy process, as I understand it, not a Children Act practitioner, on the birth certificate, because you can't have two fathers. And they both care and love baby Timothy for 5 years, financially supporting him, caring for him, meeting those nursery fees. And baby Timothy, understandably, views them both as their father, as his father. But again, heartbreak, they separate. So they're not living together, but with a hop, skip, and a jump, Mike Tyndall obtains parental responsibility and lives with order, completely to be expected in those circumstances. And baby Timothy is living between William and Mike Tyndall. So to recap, baby Timothy views Mike Tyndall as his father. Mike Tyndall views baby Timothy as his child. Mike Tyndall raised baby Timothy for 5 years and continues to do so. Mike Tyndall supported him financially for 5 years, continues to do so when he's with him. And Mike Tyndall has PR and lives with order. What are William's options under Schedule 1? Well, he doesn't have any, because Mike Tyndall is not a biological parent. He did not adopt baby Timothy. He couldn't be, under Operation Surrogacy laws, put down as father. And he's not married to William. And they're not civil partners. So we can have the bizarre, frankly, situation where in the first universe we looked at, William can hypothetically claim against George Clooney, who he has never met, has no biological link to the child, who does not have parental responsibility or lives with order. But William cannot make a claim against Mike Tyndall. And of course, if we flip this around, Mike Tyndall can make a claim against William because he has lives with order. And William falls within the definition of a parent. For our third and final multiverse, we're going to go back to Kate and William. I'm going to slightly step out of the cohabitant arena, more just to show you how mad this is. Again, they're deeply in love. Again, they have, oh, I skipped one there. You can see where we're going. Prince Louis is their child. Tragedy strikes. William dies in a skiing accident in Courchevel. Naturally, Kate is heartbroken. She's really struggling. And so William's father steps into the role, and King Charles obtains PR and lives with order, and Prince Louis lives between King Charles and Kate. And ultimately, Kate runs out of money, and despite having a lives with order, she can't really afford to support Prince Louis. And so Prince Louis lives more and more with King Charles, and he provides him with all his needs, as you'd expect the king to do, pays his private school fees and so forth. And so again, we have another rather bizarre situation where King Charles, in this circumstance, has PR and lives with order, is supporting him day to day, meeting the school fees. He's biologically related to him. But again, there is no route for Kate to claim under Schedule 1. So before we look at where the act or interpretation of the act has gone wrong, there are 3 points for the practitioners in the room to kind of remember that I would suggest with your clients. First, when you represent somebody who is looking to become or take a step to become a legal parent where they are not a biological parent, they need to be warned of the financial consequences to them of doing so, because in the current interpretation of the law, they are likely to be able to get PR and lives with order in the circumstances we've been discussing, but have no financial consequences when doing so. Conversely, if you represent the biological party, you definitely want to encourage the other parties to take those steps to become a legal parent. Second, on remarriage, we should be alerting a client to the risks of, which include a Schedule 1 claim on second marriage, or marrying somebody who has a child with somebody else. And third, you always need to be aware of who a respondent can be. The scenario I gave you of the King Charles situation where the parent died was a case I had. So these do happen. Next, looking at where did the act go wrong. First, it's clear, isn't it, that the intention of the drafters was that they did not intend for respondents to an application to only have to be biologically related to the child. Otherwise, you would not have paragraph 4.2 and paragraph 16. And parties like George Clooney, who on a traditional viewpoint, probably best viewed as a step parent, they wouldn't feature at all. And as I say in the slide, George Clooney could even be separated from Kate and have never met William and still technically be a respondent. Second, the drafters chose specifically not to define what a parent is, aside from including them in paragraph 16, the parents by virtue of being in a marriage or civil partnership and treating the child as a child of the family. And third, plainly, the drafters were content for the court to have a discretion before making an order with respect to a party who is not a biological parent. And you can see in the slide the areas of discretion, whether, in what manner, extent, length of the period. There's a huge amount of discretion there for the court to exercise. So any floodgates arguments seems likely to be quite redundant. The issue was considered by Mr. Justice Moylan in T and B, and it's been 12, 13 years since then. And in my view, the time has really come to resolve this point. And the problem really is that the structure of the Act as it's interpreted by Mr. Justice Moylan is to look for a change in legal status to unlock Schedule 1. So what you're looking for is being a biological parent, adoption, surrogacy, or marriage or civil partnership, which for cohabitants overemphasizes, in my view, in certain circumstances, marriage or civil partnership. And that's ultimately quite a narrow straitjacket, particularly in the world and society we live in today. And especially so where under the surrogacy legislation, you can only record one father. What's the solution? Well, in my view, the solution plainly is who can be a respondent and how that is classed. And we can achieve that either through statutory reform, as Graeme has just discussed, which would likely take a long time. But if not that, then it could be altered through statutory interpretation through the courts, either by way of a plain reading of what a parent is, given the statute does not define it, or reading in wider language through Section 3 of the Human Rights Act. Dealing with the first of those, the court could interpret parent more broadly than Mr. Justice Moylan did in the circumstances of Schedule 1. He was invited to identify within the case somebody with parental responsibility as a parent, and he declines to do so. And on one reading, that's quite a conservative judgment in the context of Schedule 1 of what a parent is, particularly in circumstances where paragraph 16 exists. Plainly, parties to a marriage are not parents in any other context aside from within Schedule 1 and perhaps as viewed by the child, I suppose. And just as with paragraph 16, a paragraph 16 party like George Clooney, anyone with parental responsibility who is not a biological parent would have to go through paragraph 4.2 and the discretionary test already laid down by the court there. So it does seem like quite an obvious route to open it up to those with parental responsibility. Finally, in T and B, Mr. Justice Moylan was only given limited submissions on the breach of the applicant's convention rights. And he wasn't given submissions on Article 14, which addresses discrimination between analogous parties. And it would certainly seem that there are some glaring discriminatory outcomes as a result of the structure of Schedule 1. The situation between William and Mike Tyndall is plainly analogous to the situation between William and Kate. There's no reason why they should not be treated equally. And I suspect a court seized with an Article 14 question on that point would be quite concerned to see the discrimination play out. Before I lose my voice, that's all from me. Thank you. You too.
Now, last but not least, we have Elizabeth Darlington, who is a barrister at 1GC Family Law. So it's wonderful to have Elizabeth in this session, given her wealth of expertise in cohabitation law. She's authored several practitioner texts on the subject, and she's also a member of the National Committee of the Family Bar Association, and it's views from the Family Law Bar Association that she's going to share with us this afternoon in her talk. which is, as you can see, to lay out claims and the views of the FLBA in respect of law reform.
Thank you. Well, it's great to be here with so many experts in this field and to be in person as well. And it's lovely being in this this building in a temple, even though I'm a member of Middle Temple. Fantastic facilities there also, but I have to say this auditorium is pretty impressive. So I've been asked to talk about the views of the Family Law Bar Association in respect of cohabitation reform. And that's perhaps not as easy it might first be thought, because obviously members of the bar are all independent practitioners. And I'm told by John Wilson KC that in 2007, when the FLBA was asked to provide a response, it was in fact unable to provide a uniform response because of the differing views amongst practitioners, and so individual responses were provided. But on this occasion, we did provide a uniform response. The FLBA has over 1,700 members, and the National Committee has a Finance and Property Subcommittee on which I sit. And for the purposes of providing the response, a number of experts, expert barristers with a lot of experience in this field were co-opted onto that committee. And that includes John Wilson KC and Michael Horton KC, who will be speaking later. And Michael and I gave evidence on behalf of the FLBA to the Women and Equalities Committee. So I'd like to first of all summarise the views of the FLBA, but then I'd like to go on to look at some of the issues which commonly occur in practice at the bar in England and Wales, and that I've got first-hand day-to-day experience of. So first of all then, the FLBA's views. It's perhaps worth prefacing my comments in relation to that by referring to Baroness Hale in the case of Gowan Grant, where she said that there's need for some such remedy as this in England and Wales, referring to the Scottish legislation. Well, as we've heard from Kate, that's now being considered for reform, and England and Wales haven't even got to that stage. And the view expressed by Baroness Hale was endorsed in the response of the bar and remains the view of the FLBA. And so in broad terms, the FLBA supports proposed changes to the law recommended by the Law Commission in 2007. One of the recurring themes that I'll come back to is the question of costs in respect to litigation in this area. And so the FLBA supports amendments to the family procedure rules in respect of costs, so that there's no financial penalty for a party who brings proceedings. We spent quite a lot of time considering the definition of cohabitation, and the conclusion that we came to and that was agreed was that the best and most workable definition in practice would be living together as if they were a married couple. And that draws on much of the other legislation in respect of cohabitants, particularly social security legislation, where that expression's used. And as practitioners, we thought that that would be the most workable option. But listening to Andy this morning, I see that perhaps we're slightly behind the curve on that, referring to the comparison with married couples, and that was quite interesting to hear. The broad view was that there should be a threshold requirement of 2 or 3 years cohabitation before any rights were generated under legislation. And just continuing in respect of definitions, one of the things that we acknowledge and recognise as practitioners was the need for certainty, clarity and consistency, whilst recognising that definitions are to quite a large extent questions of policy. But in broad terms, we took the view that any legislation should have a limitation period as under the Inheritance Act. We agreed with the general view that there should be no requirement to opt in, but that there should be a cast iron right to opt out. And there should not be the same protection as married couples. In terms of death, the FLBA supported the Law Commission's recommendations in 2011. In respect of children, the members of the committee that dealt with this particular aspect spent some considerable time considering the legislative background to implementation of Schedule 1 of the Children Act. And the historic aim of, as Joshua's mentioned, of equalising the outcome for the children of married and unmarried parents, in particular in relation to outright capital claims, and concluded that Schedule 1 fails in that aim. And again, the recommendations of the Law Commission report in 2007 in respect of applications for a financial settlement order were approved, and that was the view of the FLBA that that should be implemented. In addition, that the court should be empowered to order periodical payments solely for the purpose of meeting childcare when for the costs of separated parents. But being perhaps realistic and pragmatic, if there was no new legislation, then the FLBA took the view that at least jurisdiction should be granted to the family court to hear Talata claims, that case management for cases involving both Schedule 1 and Talata proceedings should take place, so they're at least listed before the same judge, and that there should be clarity in respect of costs orders where there are both Talata and Schedule 1 proceedings. So that's a very quick skip through the views of the FLBA. And I just want to move on, as I say, to look at difficulties that I experience in practice, and no doubt other practitioners do also. And the recurring themes in this section of my comments are those of cost, complexity, and delay. So starting off, when cohabiting couples split up, they'll usually now seek advice from family practitioners, solicitors, or legal advisors. My experience, having started doing these kinds of cases back in the early noughties, so just over 20 years ago, was that I was instructed quite often, more often than not really, by civil solicitors or advisors. But as time's progressed, I've personally noticed a move away from that. And now the vast majority of my instructions come from family solicitors, which reflects, I think, the view that there is that this is a family issue. And so those practitioners are more familiar with, obviously, with the family procedure rules, because those are the rules under which they operate on a day-to-day basis. And understandably, may not have the necessary knowledge and experience, or indeed confidence, to deal with Talata cases, cohabitation cases, which are dealt with in the county court under the civil procedure rules. And so they may need to seek advice from barristers, which in itself increases costs and causes delay. I don't want to do myself or anybody out of a job, but that is one of the issues. And continuing with the theme of cost and delay, a standalone Talata claim, so a claim arising out of a property dispute between former cohabiting couple, will be brought in the county court, more specifically in the business and property court. And as Andy said earlier, he made the comment that it's looking, so it's looking to the county court to do the heavy lifting. But as you'll all appreciate, the case law in that jurisdiction has built over decades, if not centuries. Judges in the business and property courts will do what they can to push the limits of property law, but they can only go so far. And I have to say, in my experience, judges in the business and property courts would like to not have to deal with cases that they regard as family cohabitation cases, not naming any names, but I can think of quite a few who are quite happy for those to be dealt with, not in the business and property court. Further problems arise if it's necessary to issue proceedings. There's an issue about whether you issue under CPR Part 8 or Part 7. Quite often, even the court office, when you issue your claim, the court office will send it back and say you've issued under the wrong procedure. There's an issue there also in respect of the fee, because if you issue under Part 7, because there's a substantial dispute of fact, and the claim has a value of over £200,000, which in the majority of property disputes, it does. The issue fee is £10,000, so you could be looking at having to pay that. Then the next thing that you would face in a civil Talata case is cost budgeting, which I think it's fair to say nobody really likes. Even pure civil practitioners find cost budgeting a pain in the neck. It involves filling out a very detailed table with a forecast of all the costs up to including trial that will be incurred. And so the idea is that each party knows how much they're going to spend, but it just adds another level of cost and delay and complexity. And that must be complied with, otherwise serious repercussions automatically kick in under the CPR. In practice, judges will dispense with cost budgeting if they possibly can, but strictly speaking, the CPR requires it to be done. And another aspect of that is that you need to keep under consideration whether to apply to increase the cost budget if things change along the way and other issues arise, so that at the end of the case, you can claim all your costs back. So in terms of the costs, in civil proceedings, the general rule is that the unsuccessful party will be ordered to pay the costs of the successful party, but the court may make a different order. So totally different costs regime to in the family court. And on top of that, you've got the Part 36 regime, a self-contained procedural code for the making of offers, which can be useful if in cases, but even to civil practitioners can often throw up complications and is not necessarily straightforward. So those difficulties and complexities are then compounded if you've got a concurrent Schedule 1 application in the family court. So if you've got an application in respect of children, then you would often issue your Talata claim in the county court and Schedule 1 claim in the family court. But that of itself is likely to cause further expense and delay. There's likely to be at least one directions hearing to discuss and to determine how best to deal with that going forward. In my recent experience, I had a case in the north where we had these two claims going on, Schedule 1 until later, and the final hearing had to be adjourned twice because they couldn't find a judge who got the dual ticket to deal with both claims together. So it was delayed for well over a year. And as I've said on the slide, this problem is further compounded in central London, where you issue a claim, a Talata claim in the central London County Court and in Schedule 1 in the CFC. So I think as Graeme mentioned, alternative dispute resolution is often used and can be very effective in these cases. But of course, there's an additional expense, and that also means that cases aren't being considered by the courts, giving rise to less case law and less development of the case law. So just to return to Gowan Grant, where Baroness Hale said that the Act in Scotland had achieved a lot for Scottish cohabitants, and she said that English and Welsh cohabitants and their children deserve nothing less. And I think that very accurately sums up of the view of the FLBA. Thank you.
Thank you so much. It was 3 fantastic papers, and we now have about 10 minutes or so for questions. So, right here, if anyone on the floor wants to start us off.